The Supreme Court just did something that changes gun laws in every single state in America. Not just some states, not only blue states or red states, every state. And the people most affected, the ones whose rights just expanded the most dramatically, many of them still have no idea what happened. Here is what went down. The Supreme Court issued a landmark ruling that destroyed the old system states used to deny gun permits to law-abiding citizens. The system where a government official could look at your application and say, "I do not think you need this." And that was it. Denied. No gun, no real recourse, no rights. That system is gone. Dead. Unconstitutional. And what replaced it affects you directly, whether you live in New York, California, Texas, Florida, or anywhere in between. Most people hear Supreme Court ruling and think it is just academic talk for lawyers. It is not. What I am about to break down is the difference between staying ahead of the curve and accidentally committing a felony because you did not realize which rules changed and which ones stayed the same. I am going to explain exactly what changed, what it means state by state, and what you need to do right now. By the end of this, you are going to understand your gun rights better than 99% of Americans. Before I go any further, are you subscribed? Because what I am about to explain is time sensitive. Gun laws are changing right now in real time in your state. Hit that subscribe button and turn on all notifications. Let us get into it. The case is called New York State Rifle and Pistol Association versus Bruen, decided June 23, 2022 by the United States Supreme Court, 6-3 decision. Justice Clarence Thomas wrote the majority opinion. This case did not just change the law for New York. It sent a legal shockwave through every state that had ever tried to restrict who can carry a firearm in public. For over 100 years, several states operated under what is called a may-issue permitting system. May-issue means the government may issue you a permit if it feels like it. If some official behind a desk decides your reason is good enough. New York had the Sullivan Law on the books for over a century. To get a concealed carry license, you had to prove proper cause. You could not simply say you wanted to protect yourself. You had to show a special need for self-defense greater than the general public's. You had to prove you were a specific target with documented threats and convince a licensing officer with total subjective discretion that your life was valuable enough to protect. California, New York, New Jersey, Maryland, Massachusetts, Hawaii. Over 100 million Americans, nearly 1/3 of the entire country lived under these systems. And for most of them, the answer was simply no. Your reason is not good enough. Your fear is not real enough. You are not important enough to protect yourself. That was the system. And the Supreme Court just burned it down. Let me paint you a picture of how this actually worked. You are a law-abiding citizen with a clean record. You want to carry to protect yourself and your family. You apply for a permit, and then you sit across from a government bureaucrat who has never met you, never walked through your neighborhood at night, and they get to decide whether your fear is valid. They look at your reason and say general self-defense is not enough. Lots of people want to defend themselves. That does not make you special. Denied. Not because you are a criminal, not because you failed a background check, because some official did not think your reason was compelling enough to exercise a constitutional right. If you were a celebrity or politically connected, maybe you got approved. If you were a regular person, a shopkeeper, a night shift worker walking to your car alone, a single mother in a high-crime neighborhood, more often than not, the state said no. That is what May issue looked like. That is what the Supreme Court said is unconstitutional. Two men in New York applied for unrestricted concealed carry permits for general self-defense. Both were law-abiding citizens. New York denied both. They sued. The case went all the way to the Supreme Court, and the court sided with them decisively. The core holding is this. The Second Amendment protects an individual's right to carry a handgun outside the home for self-defense. If you are a law-abiding citizen, the government cannot force you to prove a special reason to exercise that right. Think about any other constitutional right. Can the government tell you that you can only speak freely if you prove your speech is important enough? Can they require you to justify your Fourth Amendment rights before you are allowed to have them? No, because rights are not privileges. They are not gifts the government hands out when it feels generous. You have them automatically. The government can regulate how you exercise them, but it cannot demand you justify why you want them in the first place. Let me be completely clear about what this kills. May issue permitting systems are unconstitutional. The proper cause standard in New York is dead. The justifiable need standard in New Jersey is dead. The good cause standard in California is dead. Maryland, Massachusetts, Hawaii, all of their discretionary denial systems are gone. What replaces them is called shall issue, and the difference is everything. Under may issue, the state may give you a permit if it wants to. Under shall issue, the state shall give you a permit if you meet the legal requirements. No more subjective judgment, no more bureaucratic gatekeeping. No more proving your fear is real enough by someone else's standards. If you are a law-abiding adult with no disqualifying criminal record and you meet your state's objective requirements, the state has to issue the permit. Period. Now here is something most people completely miss about Bruen that may be even more important than the permit ruling itself. Before this decision, courts used intermediate scrutiny to evaluate gun laws. The government just had to show a gun law was reasonably related to an important government interest. That is a fairly easy bar. They say public safety, cite some statistics, and win. Bruen threw that framework out completely. The new test is what Thomas called the text, history, and tradition test. Now, when the government wants to defend a gun law, it must prove that law is consistent with America's historical tradition of firearm regulation going back to 1791. If New York wants to ban you from carrying in a park, it cannot just say safety, it has to find an actual historical law from the founding era that is a genuine analog to the modern restriction. If it cannot find one, the law is unconstitutional. Assault weapon bans, magazine limits, waiting periods, red flag laws, all of them are being challenged under this standard right now. Some will survive. The ones that cannot find historical grounding are getting struck down. Do you think the states pushing these bans should be stopped by the courts? Drop a comment and let me know. And smash that like button while you are down there. Let us get specific state-based state because this hits differently depending on where you live. New York was at the center of this case and had the most defiant response. Before Bruen, New York City issued permits to regular people at a rate that was almost comically low. After Bruen, New York had to scrap proper cause. It did, but then immediately passed the Concealed Carry Improvement Act, adding sensitive location restrictions, mandatory training, in-person interviews, character references, and social media checks. They could no longer deny you subjectively, so they made the process as complicated as possible. Gun rights groups immediately filed lawsuits. Some new restrictions have already been blocked by federal judges. The fight is ongoing, but the core right is established. California eliminated the good cause requirement, but responded by dramatically expanding prohibited locations, schools, parks, public transit, bars, hospitals, stadiums, and any private business that does not explicitly welcome firearms. Some of those expansions have already been blocked by courts. The map is still shifting, but the default has flipped. You can now apply and expect approval if you meet objective requirements. New Jersey's justifiable need standard is gone. Applications surged from hundreds per year to thousands immediately after the ruling. Maryland and Massachusetts lost their subjective standards too. Hawaii, arguably the most restrictive state in the country, tried to claim geographic isolation warranted different rules. Courts rejected that completely. The Second Amendment does not have a Hawaii exception. For people in Texas, Florida, and other already permissive states, Bruen matters to you too. It locked in the shall issue standard constitutionally, so states cannot slide back. And the new historical test is benefiting gun owners across every jurisdiction as questionable laws get challenged. Let me make this real with 3 scenarios because legal theory means nothing until you see how it changes actual lives. You work nights at a hospital in Los Angeles and walk to your car alone at 2 in the morning. You have been followed twice. Under the old California system, the county says 2 incidents are not enough. Lots of people feel unsafe denied. Under Bruen, you apply, complete required training, pass the background check, and the county has to issue the permit. Your reason is self-defense, which is the reason the Second Amendment was written. You own a small convenience store in Newark and have been robbed twice in 3 years with employees threatened at gunpoint. Under old New Jersey law, a bureaucrat still decides whether your documented robberies constitute justifiable need. Maybe they say higher security instead. Denied under Bruen. Justifiable need does not exist anymore. You meet the requirements and you get the permit. You live in Hawaii with 3 kids and want to carry to protect your family. Not because of a specific threat, because you believe in being prepared and because the Constitution says you have that right. Under the old Hawaiian system, denied before you finish the application. Under Bruen, you apply, complete training, pass the background check, and Hawaii has to issue the permit. The ocean does not change the Constitution. Now, here is where it gets dangerous if you are not paying attention, because restrictive states are not accepting this since they can no longer deny you for subjective reasons. They are trying to make the permit useless. New York and California both passed emergency legislation after Bruen designating almost every public space as a sensitive place where carrying is prohibited. Parks, public transit, bars, any private business without a sign welcoming firearms. They are trying to create a patchwork where you technically have a permit, but everywhere you might want to use it is a felony zone. Some jurisdictions also added social media audits and broad character requirements as a backdoor to restore subjective denial. Gun rights groups are already back in court arguing these are just proper cause wearing a mask. Let me bust 3 myths spreading fast because getting any one of them wrong could get you arrested. The first myth is that Bruen means you can carry without a permit. Absolutely not. The court ruled that Mayes issue systems are unconstitutional, not that permits cannot be required. If your state requires a permit, you still need one. Do not start carrying without going through the proper process. The second myth is that all gun-free zones are unconstitutional after Bruen. Wrong. The court explicitly acknowledged states can designate sensitive places where carrying is prohibited. Many of the new expanded restrictions are still in effect while being challenged in court. Know your state's current list before you carry anywhere new. The third myth is that background checks and training requirements are gone. Wrong. Justice Kavanaugh's concurring opinion made it clear states can still require background checks, fingerprinting, and safety training. The court is not saying the government cannot vet you. It is saying it cannot arbitrarily deny you after you clear that vetting. Step back because Bruen is not isolated. It is the third movement in a deliberate progression. Heller in 2008 established the Second Amendment as an individual right in the home. McDonald in 2010 made that right apply to state and local governments. Bruen in 2022 extended it to public spaces and made gun laws dramatically harder for the government to restrict. Each case builds on the last, and more cases are in the pipeline. The American landscape for gun owners has split into 3 zones. Freedom states like Texas and Florida that do not require permits at all. Where Bruen locked in constitutional protection against future rollback, compliant states like Ohio and Pennsylvania that were already shall issue, where Bruen simply reinforces the national baseline. And battleground states, New York, California, New Jersey, Maryland, Hawaii, and Massachusetts, where laws are changing weekly. If you live in a battleground state, you cannot afford to be casual. Check your local laws regularly. Join a state-level gun rights organization because they are filing the lawsuits and will alert you the moment something changes. Here is what to lock in before you walk away. May issue permit systems are constitutionally dead. You cannot be denied a permit simply because a government official does not find your reason compelling enough. If you are a law-abiding adult who meets your state's objective requirements, the state shall issue the permit. All gun laws are now evaluated under the stricter historical test, and laws that cannot clear that bar are being struck down, and the trend is not stopping. Heller McDonald Bruen, the constitutional floor for gun rights is higher now than at any point in the modern era, and it may go higher still. Subscribe right now and turn on all notifications. Hit the like button if this gave you information you actually needed. Drop a comment telling me what state you are in and whether you have noticed changes to carry laws in your area. Share this with someone who carries, someone who has been denied a permit, or someone who thinks they cannot get one because the law changed. And knowing that change is the difference between living in fear of a right you do not know you have and actually exercising it. Stay safe, stay legal.